and then we'll start back in at 2 o'clock, if that's okay.
Let me first read the item back into the record. Item 55 is amendments to the Land Development Code and the city's local postal program pertaining to medical marijuana dispensaries, and amendments to the San Diego Municipal Code relating to medical marijuana regulations for qualified patients, caregivers, and consumer cooperatives. The ordinances were introduced as amended on March 28, 2011 as item 200, sub-item A and sub-item B. Council voted 5-2, and council members Mayo and Zapp voting nay, and Councilmember Alvarez not present. We do have a number of public speakers. Starting with the opposition, Jeffrey Lake has 12 people who have ceded time to him. Let me read those names into the record. Nathan Shaman, Lance Rogers, Jessica Elfresh, Melanie Mackert, Jessica Amacker, Lynn Ballantyne, Helen Milligan, Monica Jackson, Adar Lamasan, Mike McKee, Charlene Moran, and Richard Amundson.
All right, I'll give you 10 minutes.
Thank you, council members. Again, for those of you that don't know me, my name is Jeff Lake. I'm a lawyer here in town. I spent a few minutes at the first reading talking about some of the legalities that this council will hopefully consider when evaluating the vote on the upcoming ordinance. I wanted to follow up with a few things that we didn't discuss last time, but I think are going to be critically important when it comes to making your decision. First is why the ordinance needs to be amended even further. We've taken some good steps, but there's a couple more things that I think need to be implemented in order to make this a fair regulation as opposed to a prohibition. And they're very simple. One, we need to expand the zones where medical marijuana dispensaries should be permitted to operate. I would propose that we do it consistent with the Medical Marijuana Task Force recommendations. Secondly, is to reduce the amount of setbacks. Right now, the way that the setbacks are incorporated, it is almost impossible to find not only a proper zone, but something that is within 600 feet of anything. California state law requires that medical marijuana dispensaries be set back 600 feet from schools. I think that is what we need to look at, and we need to consider the amendment along those lines. And lastly is the issue of amateurization or grandfathering. Those are two concepts that are very similar. Number one, grandfathering means that an existing business that is a pre-existing non-conforming use be allowed to remain under certain circumstances. Secondly is amateurization, which means that if a business is going to be required to leave, that it's given a reasonable amount of time in order to make that transition. I think a combination of those four amendments will get us where we need to be on a reasonable legislation that will give the medical marijuana community, the public safety, and the citizens of San Diego everything they need when it comes to safe access. I wanted to make a couple other points for you to consider, and one of those I think is important for you to realize, but you may not know, and that is what the city's current position is in regards to medical marijuana dispensaries. And what it is right now? Nothing. There is no ordinance. There is only an opinion from DSD that says there is no applicable zone for a medical marijuana dispensary. That is very vague. It's very broad. I think that's unenforceable by itself, which is one of the reasons we've seen the city attorney's office resort to the current enforcement policy against medical marijuana dispensaries. And that is, the city attorney's office is expending a tremendous amount of pressure on the landlords. They're not going after the dispensary operators themselves. They are expecting, encouraging, and positively intimidating landowners to sue their tenants. And that's just wrong. That's bad government. This is a city issue. This is not an issue where a landlord in a depressed economic setting, commercially particularly, should be required to sue their own tenants to enforce a government policy. That's not the way this needs to be done. And I know that's what's being done because we're involved in many of those cases right now. So first, please, take this out of the hands of the landlords that are reluctant at best to sue their own tenants and take money out of their own pockets and leave their commercial spaces open. Make sure that this council does the right thing and enact reasonable legislation. One of the things that I've spent much time speaking with many city civic leaders about is federal preemption. I know that everyone here is worried about the conflict of law between federal and state law, and a lot of legislators are concerned about their downside liability exposure for enacting a local ordinance that may be in conflict with federal law. That question's been settled, folks. It was settled by the California Supreme Court in the Qualified Patients versus the City of Anaheim case when it comes to the enforcement of Senate Bill 420, in which the legislature of this state delegated the responsibility of local zoning to the local municipalities. There was an issue as to whether or not a local city or county could enact a law that may be in conflict with federal law. When it comes to zoning, particularly the ordinances requiring the operation of businesses that are compliant with state law, there is no federal question. There is no federal preemption. There is no need for anyone here to worry about the federal government coming in and trying to overturn a law that you enact when it comes to the regulation of medical marijuana collectors and their dispensaries. Please just dismiss the idea of federal preemption. It shouldn't be a concern. We need to be talking about compliance with state law. Now, one thing that the federal and state governments do agree on is that the amount of revenue that's generated by the medical marijuana industry is significant, and it's important. So the question becomes, how do we, as a city, take good dollars, whether they're from federal tax dollars, whether they're from sales tax dollars, whether they're from fees or taxes that can go directly into the city's general fund to be used for public health and safety, and lots of other good, productive reasons, as opposed to embarking in a long, arduous, expensive, and I would say wasteful road of litigation and spending of taxpayers' money. And there's an answer to that. And the federal government itself, through the highest tax court in the land, has actually answered this question. And it's in a case called Champ versus the IRS. And that case talks about federal IRS Rule 280E, which says, federal government, this is our federal government again, on the one hand, the distribution of a Schedule I drug is illegal for all purposes, and if the Department of Justice, the U.S. Attorney's Office wants to prosecute you, that's up to them. On the other hand, the federal government says, but if they don't, and as we know because of Obama's policy position, they're not prosecuting collectors, and you're compliant with this state law here, SB 420, Prop 215, then you need to pay your federal taxes. And the only deduction you can take is the cost of goods sold, unless you meet the test in the Champ case, which says that if you are operating your business as a dual purpose, and in this industry, it's about holistic wellness centers, it's about alternative care. You're probably going to hear lots of testimony from qualified patients that are going to tell you how important their medicine is and why they like homeopathic medicine as opposed to pharmaceutical medicine. That's not what I'm here to talk to you about. What I want to reiterate is the IRS is on your side. They are going to require all medical marijuana dispensaries to serve a dual purpose, or they are not going to get their federal tax deductions that they need. They are going to need to operate as holistic wellness centers. We're not talking about fly-by-night dispensaries, folks. We're talking about putting together a system where qualified patients can go to not only get their medical cannabis, but that they can also get other natural and organic healthcare products, where they can get homeopathic remedies, where they can see medical providers that are not discriminatory against medical marijuana patients. That is what we're talking about. That is what everybody in the medical marijuana community wants. That is the direction they're going because they have to. They have to, under federal law. They can be compliant and not have to worry about federal preemption. They have to meet the state laws, and if they do, I think you're going to see a dramatic change in the way that medical marijuana is offered to the qualified patients, how it is assimilated into local communities, and how the city can develop a great tax base, how they can have a positive economic influence, how they can drive money straight into the general fund that can be used for lots of projects. We've already heard some testimony about that today. So again, I will urge you to consider 4 simple amendments. They've already been recommended by the Medical Marijuana Task Force that you employed. They are consistent with state law. They are not in violation of the federal preemption. They will help everyone here. So again, I urge you, please don't waste the taxpayers' money fighting a losing battle. Let's use that money productively. Thank you very much.
Schmachtenberger has 14 people seating time. Let me read their names into the record. Andy Granada, Sam Bickel, Bill Bliss, Joe Kashat, Justin Turley, Britton Babcock, Terry Best, Andy Delgadillo, Chris Hansen, Keith Chen, Jordan De La Cruz, Mike Bongiorno, Yocuba Cervantes, and Rebecca Robinson.
Okay.
Go ahead.
Got a PowerPoint set up. Dear Council, I'm here to present some information that I don't think that you've seen yet that I believe is pertinent to being able to make an informed decision on the medical marijuana topic. Go to the next slide. The goal here is to be able to present fact-based information as opposed to opinion-based information to allow you to make a sensible decision on the topic. With the information presented, one of our goals is to demonstrate the need for modifications to this current ordinance and to propose the specific amendments that are needed. Next slide. One of the things I'd like to start with is addressing the concerns that you as council and opposition brought up in the last council meeting. There were concerns about how to regulate dispensaries and what the potential problems are from having too many of them or in too unregulated of a fashion. The first concern was that the presence of dispensaries increases crime. If you go to the next slide, I pulled the crime statistics off of the City of San Diego's website and shown in every major category from 2008 through 2010, which represents the time in which dispensaries have shown up most significantly in the city, that in every single category there's been a drop-off in crime from year to year. Now, it can't be said in any significant way that that's directly attributable to dispensaries coming into existence, but it also clearly can't be said that it increases crime because the numbers don't reflect that. So based on the information provided by the city, there's no evidence to support that there's any increase in crime. One of the questions was even robbery, but you see that there's a decrease in robberies every single year. So from a crime standpoint, there's really nothing to indicate that there's any reason to overregulate dispensaries. Next slide, please. One of the other concerns was that having marijuana readily available through dispensaries and other fashions increases the use by children and teens. If you go to the next slide, you see a graph put out by NIDA. This is the National Institute on Drug Abuse, a government agency. Unfortunately, this is the most current graph that they have, but it shows that there's a steady decline in use of marijuana and other illicit drugs on the left-hand side from year to year, while there's a steady incline of abuse from opiates. So as far as the concern of whether or not the presence of marijuana or the promotion of it really significantly increases use by children and adolescents can't be substantiated based on government information. Next slide. One of the other concerns, and this one was brought up by a couple council members as well as members of the audience, which is not the right word. People abuse the system to use marijuana recreationally. If you go to the next slide, basically there are no documented cases that actually evidence this. It's something that, though I won't argue never happens, there actually are no cases in San Diego where people have been tried for or documented for abusing the medical marijuana system to gain access for recreational purposes. Now, we're not talking about whether marijuana should be allowed for recreational purposes or not, but since the topic continues to get brought up, I think it's important to show the statistics and what the effects of marijuana, even used recreationally, are in comparison to other common substances. If you look, the death toll every year in the US alone from tobacco use is 435,000 people. Alcohol kills 85,000 people, and overdose from prescription drugs kills 32,000 people. There has never been a single documented death as a result of the use of marijuana. So whether you're looking at this from a recreational standpoint, a medical standpoint, there's no evidence to back up the risk of marijuana that would cause the council to want to overregulate this issue. The next concern that was brought up repeatedly was that seriously ill patients, it makes sense for them to have safe access, but what about all the young people, the patients that are in their 20s and their 30s? And if you go to the next slide, even though some younger patients may not appear physically to be dying or close to it or significantly ill, if you look at what some of the common ailments are that affect young people, we've got insomnia, chronic pain, and PTSD are three of the most common ones that affect people in their 20s, 30s, and 40s. And if you look at, marijuana has been shown to be extremely effective in all of these issues. And I just want to point out, from a prescription standpoint, if you look at what the alternatives are and side effects, it's pretty scary, actually. For insomnia, the main alternative from a allopathic medicine standpoint is Lunesta. If you look at the side effects, and these were pulled directly off of Wikipedia, we've got headaches, painful urination, aggressive behavior, and suicidal thoughts. Now, when you compare that to marijuana, where the only documented negative side effect that has ever been shown is coughing, which was documented by Dr. Donald Hashkin out of UCLA, funded by the National Institute on Drug Abuse, only documented side effect ever. Compare that to suicidal thoughts, it's significant. Chronic pain, one of your main options is going to be Vicodin. You're looking at nausea, seizures, hallucinations, and jaundice. PTSD, we're looking at an option of Celexa. There's a bunch of them, but this is the most common treatment. With Celexa, you've got sexual dysfunction, insomnia, nausea, cardiac arrhythmia, and convulsions. These are major, major side effects that can all be alleviated by having safe access available for the elderly as well as the younger patients that are in need. And these are just a very short list of the side effects. The side effect list is actually about 2 pages for each one of these. I just picked a few pertinent ones. Next slide, please. This list, though I know you can't read it because the text is too small, is a list that was produced by Dr. Todd McCurry, who is the former director of the National Institute on Mental Health. This list is the most comprehensive list to date of all of the different conditions that are treated by medical marijuana. So when you say that patients that are 20 and 30, 40 years old shouldn't be using it, when you look at the number of different conditions that marijuana has been documented to be effective with, and this isn't documented from an anecdotal standpoint, these are all conditions that have been...
Need to summarize.
So next slide, please. I want to just briefly talk on the financial impact in terms of both loss of revenue and additional expenses that are going to be incurred. We did a comprehensive poll of dispensaries throughout San Diego to get a breakdown of how many patients they have, how many they see, what types of numbers are processed. There's 70,304 estimated patients within the city of San Diego. That makes up 5.1% of the entire population. We have a breakdown of how many dispensaries and how many patients are in every single district. Next slide. With all these numbers, what we came out with is that there's slightly over $200 million in the annual revenue processed through the dispensaries. When you look at what that equates to in sales tax from a state level is $16.5 million, the city gets just over $1 million of that. You're going to be taking away over $17 million from the city and state budget and sales tax alone. Next slide. Lost jobs. There's 1,917 individuals that are employed by dispensaries. If you look at, according to the EDD, the average unemployment is $1,256 a month. Multiply that by all the ones that are going to be put out, you're adding an annual impact to the state of over $28 million to cover the unemployment alone. Next slide. Next thing to look at is what the cost is going to be to enforce and implement this, knowing that there's going to be opposition. There's no great statistics to really be able to support this in a significant way, but one thing we do know is that it cost the city of San Marcos over $800,000 to prosecute a single dispensary to try to get them to shut down. And that was just to the point of preliminary injunction. We have 144 dispensaries in San Diego. From talking with the law firms, we know at least 50% of them are planning on pursuing lawsuits. The numbers that could reach in terms of San Diego could be dramatic. Next slide. So total financial impact, I'm estimating $5 million in enforcement costs. And then you can see here what the graph is in terms of lost taxes, increase in expenses, both from lost jobs as well as enforcement.
Right.
Right on the very tail end.
Yes.
Um,
Just summarizing and then we'll
okay. So In summary, is it able to get the summary slide?
You can just summarize it.
So in summary, by passing this ordinance, you're going to be leaving over 70,000 patients in San Diego without any access to marijuana for over a year, making it extremely difficult after that point. Passing the ordinance without amendments will have significant financial impact to the city, and there's no fact-based or reason to be able to substantiate that this ordinance is actually in the best interest of the people, especially when you factor the numbers that have shown up. So we're asking for 4 amendments. The 4 amendments are a 2-year compliance period.
Yeah, that's the issue. We gotta move forward. We don't have but a hour this afternoon. But I think your presentation was very interesting. Thank you.
I'd be happy to provide all the statistics and everything to back that
Why
up.
don't you give it to my staff and we'll copy and give it to everybody here on the council.
Thank you, Mr. Young.
Thank you.